Hi, my name is Brenda Waugh, and perhaps we've met through a free consultation, or perhaps you have gone ahead and scheduled your mediation. Um, if you're receiving this video, chances are that you are preparing now for your mediation, and so this will help you to be able to prepare. So welcome. I'm looking forward to working with you. Doing family mediation is a part of my job that I really enjoy. I like working with families and helping them figure out how to restructure things when the parents are no longer going to be married. A lot of folks feel like it is it's a tough time, and it is, and it's challenging, but also it's an opportunity to try to create the family that you want by being very intentional about the whole process and being transparent and working together, collaborating to find the best possible resolution for your family. So if you've chosen mediation, that's what you're looking forward to. You may also like that it's also the most cost-effective way to be divorced. So anyway, welcome, and let's get to it. This is going to be quite a lot of information. And if you feel confused, just jot your notes down, and I will be happy to answer them in mediation. Again, this might be too much information, but I want to make sure that you have the opportunity to get this information and save you money, so you're not having to ask me questions when you're having to pay by the hour. So anyway, welcome. I'm sorry if it seems like it's a lot. Please don't worry if you feel like you don't understand something. We can talk about it at your pre-mediation meeting and make sure that that you feel very well prepared when we go into the mediation. Here's pretty much what we're going to talk about during this short video, just to try to get you ready for mediation. Just please be patient, and we'll just kind of plow through each of these things. We're going to look at what the process looks like, how to get prepared for it, and then how to stay in touch with me while we're working on your case. So getting started, and I think you've probably already done these things, but if not, you will have signed up for mediation. You've signed the agreement to mediate. You have a pre-mediation meeting scheduled as well as your mediation, and you've met with Mackenzie. You may already have Basecamp, our collaborative tool, and forms to help you prepare for the mediation. So once you've got those things together, we will have a pre-mediation meeting. Hopefully you'll watch this video before that, and you will be there and you'll be able to ask questions. We are going to review the documents that I need for you to bring to mediation. And then after the pre-mediation meeting, you're going to be gathering the information we've requested. It's very important that we figure out what you need, because bringing everything to your first session will save you time and money, and will likely expedite the process. What happens at mediation? What is the schedule of events during the mediation? When we get to the mediation, we'll figure out what your pressing issues are. If you don't have any pressing issues, then we often start with the property settlement agreement. We go through and value the property, figure out what divisions you guys have been thinking about using, what divisions might be better, what our options are, and then we work on creating a parenting plan. At the end of the mediation, we kind of look and see where we got to and see what we need to do to follow up. So you're going to have a pre-mediation meeting where you're going to learn what's going to happen at mediation. And then at the mediation, these are kind of the steps that we will be going through. So after you've been to the 30-minute pre-mediation meeting and the 2 or 3 hour mediation, depending on whether or not it's in person, at that point in time, you'll probably have some homework. There may be some items that weren't valued, some things you wanted to think about, some more reading you wanted to do. You'll complete that homework. And then we will probably come back. We'll figure out when we need to come back. Now, sometimes I can draft the agreement after the first meeting. Sometimes we need to come back and have a second meeting before I can draft the agreement. Usually after I draft your agreement or write your agreement, we get together again to go through that agreement so you can see what it looks like, make changes, look for typographical errors and things like that. At this point, some people want to consult with an attorney before they sign. Other people are ready to sign. And at that point in time, your mediation is completed. After that final mediation, which again, it can easily be 2 or 3 meetings, your agreement can be signed. And once your agreement is signed, how you proceed is going to be up to you. Typically, sometimes people hire a lawyer. Sometimes people have had to hire the lawyer that helped advise them whether or not to sign the agreement. In Virginia, a lot of people hire a lawyer just to file the uncontested divorce. A lot of lawyers advertise a very low rate for an uncontested divorce. So when you have that written agreement ready, they will honor that rate. In West Virginia, it's very easy to file without a lawyer. The forms that you need to file without a lawyer are all available for free on the internet at the Supreme Court's website. And probably many of my family law clients in West Virginia may consult with a lawyer. Some never consult with lawyers. They sign the agreement and then they file without an attorney using that pro se paperwork. So after the mediation, that's what happens next. Now, let's go back and get to some more detail about how to prepare for the mediation. Remember, there's some key components in the mediation process. And first of all, everything in mediation is confidential. What's said in mediation stays in mediation. I can't be subpoenaed to court to say what happened in mediation. You guys can't be subpoenaed to say, didn't you say this in mediation? I thought you were going to do this. Everything in mediation is confidential. Sometimes in mediation, I like to talk to one party or the other separate from the other. That's completely normal. And what that's called is a caucus. And in a caucus, I will be meeting with one of you and the other you may step out. Sometimes I meet with both people in caucus, then we come back together. But it's not unusual to have a caucus. It's also possible that if you want to talk to me privately, you may do that by asking to speak with me in caucus. The process I use for mediation is called transformative and facilitative. There's different models of mediation. Virginia requires that I tell clients that I use generally a facilitative or transformative model. What that basically means is I am trying to facilitate an agreement. I'm working on transforming the relationship, and I am not going to evaluate your case and tell you what a judge would do. That is called evaluative mediation, and I don't do that. I've been a lawyer for a long time, and I feel very uncomfortable suggesting that I have any idea what a judge is going to do. Judges do what they want to do. So it's important for you to remember that this process is designed to help you reach an agreement that you're happy with, and that I am hopefully going to be able to help facilitate that agreement. Mediation is always voluntary. If you don't want to participate, you don't have to. But I do encourage you to try it out. And if you're come this far, you're probably already considering trying it. So it's always voluntary. And if you decide after one or two sessions you don't want to do anymore, you don't have to. It's not like the court system that it's not voluntary. It's completely involuntary once you're brought in with a subpoena. Mediation is always voluntary. Now, another thing on how to get ready for your mediation, property division. You're going to be taking a form and you're going to make a list of all your marital property. These are some of the kinds of things that are marital property. That's a pretty extensive list. If you have any questions, list it. Real property, timeshares, investment, cars, bank accounts, stocks, pension, 401k, any debt, student loans, home equity line of credit, anything that involves a marital debt or asset, list it. Also make a list of your separate property. If you have things that you brought to the marriage, maybe you have some antiques, maybe you have a collector's car, maybe you have a $10,000 bank account that you brought to the marriage that is still in your name. Maybe somebody died during the marriage and left you an inheritance, and that's only in your name. Those things are generally considered separate property, but I urge you to write it down and bring it because we need to include that. That way we've talked about it and no one can ever say, I didn't know anything about it. We need to be completely transparent and open. West Virginia, in fact, requires that you disclose all potential property. Virginia doesn't require it without a discovery process. However, it will make your agreement more solid if you list all of your assets. So even if somebody's keeping something as their separate property, list it as an asset so we can discuss it. List the property that you think is marital, but you're not knowing what to do with it because it's partially marital and partially separate, such as a house that you, one of you owned and then you remodeled it during the marriage. Just list it and list that it's partially marital and partially separate, and we'll figure out what to do about that issue during mediation. Once you've got the list of property, go through and come up with a value for all property. If you are in a situation where the two of you want to sit down together and agree on values, that will expedite the mediation process, and you should do that. If you feel like you're not in a place where that's going to be a good situation, then don't do it. It's not a good idea to get into an argument outside of mediation because sometimes it can make it more difficult to move forward in mediation. So I'm going to encourage you to make your list of property and come up with values. If they can be this, if you guys want to do your values before you come to mediation, that's fine. But if not, we can also do it at mediation. You do need to select what date you're going to check as to when your property was valued. What's the date? Do you want it to be the date of separation, the date of the mediation? Just pick a date that you're going to value property. Now, people often use the date of separation, especially if they've been separated for a year or two. People often use the date of mediation if they haven't been separated very long, because it's easy to get all the information close to that date. So those are usually probably the two that I see that are used most often, but you can agree to most any date for your valuation as long as you've got a reason for it. And so when you're thinking about dates, these are some of the factors you want to consider and what date would work best. Again, if you've been separated a long time, you probably want to backdate it to when you separated, because you may have a lot of post-separation debts and assets that you do not want to consider marital property. How do you value? You can use the NADA or Kelley Blue Book value on your vehicles. You can use tax assessment on your vehicles. If you've got records, bank records, stocks records, credit card statements. Let's see, is there a slide on? Yeah, come back. With regard to your house, most people either agree to something based on what they've seen on Zillow. You may also reach out to a realtor and get a fair market value analysis, or you may go ahead and get an appraisal. With regard to retirement accounts, you can use the value of those accounts. If it's a pension, it is likely going to need to be valued, and we will need to talk about that at your pre-mediation meeting. So, discussing spousal support, getting ready for your mediation. There are 3 types of spousal support payments. You can pay spousal support an amount each month for a specific period of time. For example, $200 a month for 10 years. It could just be periodic payments for an undefined term, $200 a month until modified by a court. Or it can be a lump sum amount. Instead of paying it over time, just lump it together and pay it immediately. So those are the 3 different ways that you might structure spousal support. I usually see periodic payments for a definite period of time. How do you decide on the amount of spousal support? Virginia has a formula for temporary spousal support, and it also has a list of factors. Both Virginia and West Virginia have a list of factors for spousal support. You can look at those, but they don't give you a whole lot of real nuts and bolts guidance. Basically, they look at the income of the parties. They look at whether or not one person has given up job opportunities to take care of the family, and the length of the marriage. Those tend to be factors that are considered most often in deciding spousal support. In collaborative laws, we use budgets, and then we set a support where we look at those budgets, we look at the child support and spousal support, and we try to make sure everybody feels comfortable. So generally speaking, if spousal support is going to be an issue in your case, at your pre-mediation meeting, I'm going to suggest that you create budgets so we have an idea of what amount would be something that everybody would be most comfortable with. There you go. If you need a budget worksheet, Mackenzie can provide that to you, so you just need to reach out to her. But if you are, either of you is requesting spousal support, I recommend you do a budget. Some reminders. Please don't feel overwhelmed. I know it's a lot, but we'll just kind of work through things one at a time. You do not need to provide documents to me, just to the other party. You can upload them to Basecamp if you want. But again, I won't be reviewing most of the documents with your numbers on it. As long as both of you agree on it, then that's fine with me. If you have worked out all your agreement and you know who's going to get something, I still recommend that you do this inventory in these numbers. It's going to make your agreement stronger. And actually in West Virginia, it's going to be required. So let's move on now and talk about what you need to do to prepare to mediate your child custody matter. All the parenting plans that we work on in Virginia and West Virginia have 2 parts. They call them different things, but they have 2 parts. One of them is about decision-making, and the other part is allocating custodial time between the parents. So here are some questions that you may want to be thinking about as you prepare. What does your child or children need to maintain the best relationship with both parents? What does your child need from a schedule? Is your child very flexible? Does your child like to have a very rigid schedule? How old's your child? How far apart, the parents live? How long do each parent feel being away from the child? How long will the child be comfortable being away from each parent? What are the work schedules for each parent? And then if you can find the annual school schedule to bring to the mediation, that's often helpful. Something else to be thinking about is, what holiday traditions do you really like? Which ones would you like to maintain? Think about what vacations you usually take and what kind of plans you might want in the future for vacations. And think about what your house rules are and what the other parents' house rules are and how consistent they can be. Moving between two houses can be hard on children. And if they've got similar rules in each house, it can sometimes be very advantageous. So that's something else you want to think about as you're preparing for mediation. Then preparing to mediate child support. Here's the numbers that you're going to need to provide for us to be able to help you run the guidelines. You need your gross monthly income. If you get paid twice every other week, then multiply it by 26 and divide it by 12. If there's overtime, we're going to need to show you the information on that because there are additional rules for overtime. Also in your formula, how much you pay for child support for any other children that aren't in this marriage. How much is the daycare, who's paying it? How much is the kids' portion of the health insurance and who's paying that? To get the children's portion of the health insurance, you often need to call your HR person and ask, or you can look and see how much it costs for you to get the insurance yourself versus insurance for your family. And that difference is what the child's portion would be. So write down your questions. Any questions you're feeling right now, any anxiety you're feeling, any worries you have, write it down and bring those questions, bring those concerns to our pre-mediation meeting. If you need anything in the meantime, please get in touch with us via Basecamp. You can also email Mackenzie or email myself, and you can call us. So thank you very much.